Well, good afternoon and welcome. My name is Nita Nicole Upadhyay, and I'm the managing partner at NNU Immigration. Thank you for joining us for this webinar titled ESTA Travel and Avoiding Detention. We have an excellent panel of speakers whom I will introduce to you in a moment, but just wanted to cover a few housekeeping comments. This panel will be recorded, and a link will be found on our firm's website within the next week or so. And also there is a chat function within the webinar platform here on Zoom. So feel free to send any questions that you've got, and I'll monitor those questions and we'll address them to the fullest extent possible. If you can, please could you send the questions directly to me as the moderator of the panel? I'd appreciate that. One final question, one final point is that, of course, each case is different. So while we want to give you as much information as we can here on this webinar, it's not intended to be legal advice. Next screen, please. So today's webinar will focus on key considerations for individuals traveling to the United States under the Visa Waiver Program, also known as ESTA. And we'll begin by addressing permissible activities under ESTA, since understanding the limitations of ESTA is critical to ensuring compliance and avoiding unnecessary disruption to travel plans. And we'll also briefly discuss alternative visa pathways for those who are not ESTA eligible or for those who are at risk of denial of entry under ESTA. We'll then discuss how to prepare effectively for travel to the United States, including practical guidance on documentation, consistency of purpose, and steps travelers can take before departure to reduce the risk of delays or denials. From there, we'll turn to ports of entry, highlighting practical considerations and the realities of inspection at US airports and border crossings. A key part of our discussion will focus on what to expect during US immigration inspection, including the scope of questioning, discretion exercised by border officials, and common issues that arise during secondary inspection. Finally, we'll address the steps to take if a traveler is detained or refused entry, including immediate considerations as well as the potential impact on future travel. So the objective of today's session is to provide clear, practical, experience-based guidance to help travelers and companies better manage risk and navigate U.S. entry procedures with more confidence despite constant policy changes. And we hope you find the discussion informative and useful, and we look forward to sharing our insights here, both from a legal and practical perspective with you over the next hour. I'd now like to introduce to you our highly experienced panel of speakers. We have Ms. Maria Venanzi. She's an NNU immigration lawyer based in Ann Arbor, Michigan, with 15 years of immigration experience focused on family-based immigration as well as business-based immigration. Thank you for being here, Maria. We also have Robert Garafola, who is also an NNU immigration lawyer based in New York City, and he's got 10 years of experience in US immigration law. Thank you for being here, Rob. And we have a featured speaker, Ramon Curiel, who joins us from San Antonio, Texas. Ramon is a partner at Olympia, Sachs, Garcia, and Curiel, and he's practiced immigration law for 25 years. He's a former chair of the AILA National CBP Liaison Committee, among many other accolades. So thank you for all being here, speakers and guests. And I'd like to pass it on to our first speaker, Maria, who's going to take us through what is and is not allowed under ESTA. Maria?
So hi everyone, and thanks for joining us today. I'm going to focus on one of the most commonly misunderstood aspects of U.S. business travel, which is what you can and can't do under ESTA, and where we most often see companies and employees run into trouble. So ESTA is popular because it's fast and it's convenient, but critically, it's also narrower than people often assume. The key point is that ESTA doesn't authorize employment or productive work in the United States. And when issues happen at the border, it's often because what employers think of as a routine business trip, like helping out in a project or jumping in to fix something, can look to US immigration officers like work, and that's where the risks start. So before we get into what activities are permitted under ESTA, I just want to take a moment to explain step by step what the visa waiver program is, what ESTA is, and what happens legally when someone travels this way. So the visa waiver program, as many of you I'm sure are familiar with, allows citizens of certain specific partner countries to travel to the US for a short visit without getting a visitor visa in advance. But it's only for business or tourism visits, and it's only for up to 90 days. So an example might be a Japanese employee flying to the US for a 3-day client meeting or a conference. They would often use the visa waiver program rather than applying for a B1, B2 visitor visa at the consulate. So it gives them the privilege, if they meet the eligibility requirements, of skipping the step of applying for a B1 business visitor visa. ESTA stands for Electronic System for Travel Authorization, and it's no more than a pre-travel screening tool that's used by travelers who are using the visa waiver program. So all visa waiver program travelers must complete the ESTA form and must have it approved in order to board a carrier that's bound for the United States. And as many of you are familiar with, it's mostly yes or no questions about identity and admissibility, things like passport details, prior refusals, immigration history, travel history, but it doesn't ask for a detailed description of what you'll do on the trip. And this is a key distinction, because ESTA authorizes travel to the US port of entry, but it doesn't authorize admission, and it doesn't authorize any specific activities in the United States. Once the ESTA is approved and the traveler travels to the United States, or in certain cases, like Dublin, there are ports of entry in Dublin, the traveler must apply for admission and be inspected by CBP, Customs and Border Protection at the airport. And critically, it's up to CBP to admit the traveler as a visitor. They will determine whether the traveler can be admitted as either a WB for business or a WT for tourism. And WB is essentially the visa waiver version of a B1 business visitor. So the same activity limits would apply. So what is generally allowed under ESTA, or visa waiver program business travel? The safest way, I think, to think about this is high level commercial or professional activity that's incidental to the traveler's employment abroad, rather than any productive services that would be performed in the United States. So in other words, it's okay to enter to talk about the business or advance the business, but not to do the business. So examples that we would usually be comfortable with would be meetings with the company's US team for strategic planning sessions, or negotiating and signing contracts, attending conferences and trade shows, or litigation-related meetings with counsel. So a practical example might be a UK-based sales director of an advertising agency flies to Chicago for a few days to meet a client, discuss renewal terms, attend internal meetings with the US account team. So they're not delivering services, they're having business discussions. And that's a classic visitor for business activity. If on that same trip, they also work on, say, design layouts, or they write ad copy, or they direct a video shoot. So now they're moving into, they're delivering the service, and that would generally not be permissible under ESTA. But, excuse me, most ESTA problems arise in the gray areas. not because someone is necessarily trying to do the wrong thing, but because normal business travel can drift into activities that US immigration law would treat as work. So we often hear well intentioned explanations like, I'm just flying in to help the US team, or I'm not being paid in the US, or it's just internal company work. But the key question is always, what is the traveler actually doing in the United States? So I want to hit on three common mistakes. So, mistake number one is travelers might say to CBP, I'm here for work, or I'm here to work on a project. And remember, work is broad and it can trigger scrutiny. So, a better approach might be to describe the activity more granularly and accurately in visitor language. So, instead of saying, I'm here for work, I'm helping the US team on a project, a lower risk but still truthful description might be, I'm here for meetings with our US team and the client to review progress, to plan next steps. I'm returning home afterwards. I'm not doing any hands on work while I'm here. Mistake number two is when helping out becomes doing the job. So if someone comes for meetings but then spends the trip while they're there producing the work product, like building deliverables or troubleshooting or operating in any way that the US team relies on, that starts to look like work. Mistake number three is assuming I'm not on US payroll, so it's fine. And while the payment source certainly matters, it's not the deciding factor. Someone could be paid overseas and still be refused if the officer concludes that the traveler is coming to perform productive services. So the question is always, what are you actually doing in the United States? What are you physically doing in the United States? Two quick additional points is CBP will also look at travel patterns. So red flags would be frequent trips, long stays, short gaps between visits. And the other thing to bear in mind is that past entry is never a guarantee. So we'll sometimes hear, I've done this for years and it's been fine, but scrutiny levels do change. We're seeing increased scrutiny at the moment. And officer approaches vary, port of entries vary. So, and your background varies at that point. So it worked before doesn't mean it will work the next time. So now the clear line, activities that almost always require a work authorized visa rather than ESTA. So again, a simple way to think of it is ESTA is for visiting, meeting, advancing the business. But the moment the trip becomes hands-on execution or operational responsibility, service delivery, you can assume ESTA is the wrong tool. So examples would be being embedded on a US project team with execution responsibility. Or this is one we see, starting a role before a work visa is issued. So what people sometimes call just getting started or onboarding. A practical rule of thumb is if it looks like something a US company would normally hire someone to do in the US, you can assume ESTA is the wrong tool. And with that, I'll hand it over to Rob, who will cover visa alternatives and when planning ahead is the safer option.
Yeah, thanks, Maria. So useful. And really what I'm the takeaway there is that ESTA authorization online does not translate to guaranteed admission into the US. So you gave some excellent examples there, and we may have some questions coming up, but we'll pass it along to Rob, who will talk to us about when a work visa or pre-clearance routing is necessary. Rob, over to you.
Yeah. Thanks, Maria. Thanks, Nita. So I'm going to start talking about when situations that would involve ESTA being a bit high risk. So I think Maria hit the nail on the head about what's permissible, what's not permissible, but she also discussed when do the lines blur? Because it's a bit of an open-ended question of what is considered productive work versus what is considered a business meeting. Those lines can blur. So now, when is ESTA a bit high risk? I think, like what Maria said, the purpose of the trip. If what you're doing is maybe partially business meetings, but if it goes beyond that, like how Maria mentioned, helping to produce the end product. So meeting with a client to understand their requirements for a project, you should be taking that information back with you to your home country and then performing the work there versus creating the actual deliverable. So if you are a software engineer, meeting with the client in the US to understand the requirements for the software they want you to produce, perfectly fine. However, actually producing the software, creating the software for the client to use there, that's bleeding into actually acting as a software engineer, software developer, doing the productive work in the US versus taking it back with you, the information to create the product. So again, if what you're doing in the US is really blurring the lines, that can cause problems using ESTA. Maria mentioned too that when you frequently travel to the US, the more trips, the more suspicion CBP is going to have that, wait, are you just coming to be a visitor or are you coming to actually work? Additionally, the longer trips, the longer duration of each trip to the US, if you're coming, but you're staying for a really long time every time, and especially if there's a little bit of gap between your trips, there's not a meaningful break between the trips, this sounds like you're just staying in the US. And if you're staying for that long, what are you doing? Are you really working? So again, these are creating scenarios where there's high risk to use ESTA. And something that we hear clients usually say is, oh, I only need to work for a week, so I don't really need a visa to do that. Yes, you do. So I just want to transition into that. So if there's a short project that you need an employee to perform in the US, that's going to be bleeding into work. That's work that requires a visa. So let's talk now about work visa pathways that you should be looking into. One of them is a handy tool called the B1 in lieu of H1B. So that's an option for a very limited project you're going to work on. We've had that traditionally before where one employee was going on maternity leave and they needed an employee from the foreign office to come and just teach the other people in the office how to use a specific software. The training was going to last about a month or so just to help people understand how to use a software system and also for the person to use the software in the US and there's specific requirements around that. The employee was only needed for a month tops and they were never going to stay in the US. They were just going to go and help on a project and then come back to the office. So that was a handy tool to let the employee actually perform productive work in the US. This also comes up too when we have very high-level executives or managers whose authority straddles multiple countries. The head of North America, they need an ability to work in Canada and the United States and Mexico, for example. So in that situation, we can maybe look to the L1 visa, which is to help to facilitate the movement of employees from a foreign office to a US office. And especially we have this with CEOs where, they need to occasionally work in the US to perform productive work for the US office to help determine KPIs, strategy growth, help land client accounts, what have you. So occasionally they do need to travel to the US to actually perform their work as a CEO, but they're not moving to the US. They're going back to their home in Canada, for example. So the L1 is a handy tool to, let especially high-level executives, managers to go to the US and actually perform work, but then also, of course, return to their home country. Another handy tool that we see for musicians, artists, or scientists, and even business executives who are at a really high level in their industry is the O1 visa for extraordinary ability. Now, this has a high evidentiary threshold. You have to be really at the top of your field, have a lot of articles written about you, publications, awards, serve on a jury of distinguished competitions, for example. So it has a higher threshold, but again, it gives you that flexibility to also work in the US. Now, strategic planning for frequent travelers. If you are a legitimate ESTA traveler and you're going to travel frequently, let's make sure you have your paperwork with you to prove that you are ESTA eligible and you're doing it for the right purpose. So having proof of your trip, the purpose, an invitation for the business meeting itself with itinerary and letter from the client, letter from the company inviting you, explaining the purpose and the dates of your travel and the meetings. Having proof that the trip is temporary, so you return airfare, for example. Look, I have my trip, it's 2 weeks. Here's a letter confirming it's a 2-week meeting, but I also have my airfare coming back within 2 weeks. Here's my ticket. Here are my hotel reservations. And, if you really want to go above and beyond, have a proof of your ability to pay your way while you're there. So if you have a copy of your bank statement showing, look, I'm not going to be paid from any US source. I don't require any US remuneration. Here's my bank statement proving I have sufficient funds to pay my way while I'm in the US. Now, let's talk about benefits of pre-clearance before I hand it off to Ramon. So pre-clearance occurs at a foreign airport, and you go through the CBP process that Maria was talking about before boarding your flight, as opposed to entering the US and going to CBP after you arrive. They're located in Ireland, the UAE, Canada, and the Caribbean. And this is helpful because before you board that flight to enter the US, you know ahead of time if you're admissible. So for that reason, I think it's a good option that when you think there are maybe too many trips you've been taking recently or really long trips and you think that you might run into an ESTA issue, if you go through a pre-clearance airport and go through pre-clearance ahead of time, before you get on the flight, yes, I am admissible to the US and I can enter. Also saves you time after that 6-7 hour flight in the US. You don't have to wait for a CBP at that point, which is kind of nice. Another advantage too that Ramon is going to talk about is, let's just say, what if you are not admissible? It's much preferable to discover that at pre-clearance as opposed to at the border when you're at the airport because of something called expedited removal. And Ramon, I think I'm going to hand it off to you now to discuss, the benefits too around that.
Thank you, Rob. I will just pass it on to Ramon in just a second. I thank you for giving us an overview on very whistle-stop tour of work options. The one thing that I'd mention to the audience is that if a work visa is required, you want to allocate sufficient amount of time. It's not going to be a scenario where if you think that you're not ESTA eligible, okay, I'll just apply for a work visa. It's going to take months. It's going to take 3, 4, 5 months, depending on the type of visa. So it will take a lot of planning, a lot of work to get to the point where you're work visa eligible. So pre-planning and having discussions as early as possible prior to travel is quite important to know if you are able to travel under ESTA or if a work visa is required. Thank you for that, Rob. We'd like to pass it over to our featured speaker, Ramon, who's going to start by telling us about what business travelers can expect at US immigration inspection. Ramon?
Thank you, Nita. Thank you. Thank you, Nita. Thank you, Maria. Thank you, Robert. Thank you for having me. I'm very happy to be here. Greetings from San Antonio. Uh, I've been I've had the honor of being part of a CBP National Committee for about 11 years. And I've analyzed a lot of CBP as an agency itself. Now, the line that I give my clients is that often clients think that immigration to the US is governed by a sole agency who's omnipowerful and whose only purpose is to make your case long and difficult and ruin your life. And that's not true. There are 4 or 5 agencies whose only purpose is to make your case long and difficult and ruin your life. But the constant between them is that they're very good at sharing bad information about you, and they're very bad at sharing good information about you. So you have to navigate all these agencies in order to get the right immigration. Now, you may forget everything that I'm going to say, but the phrase that I want you to take home with you is totality of circumstances. That phrase has been thrown to us by CBP over and over and over again whenever we reach a case, a difficult case, and we've been talking to them about a lot of situations, and I have about 35 minutes to go to tell you all the steps that you need to take. Now, the most difficult part is not defining your activity. Probably the most difficult part is the forum that we have. Okay, because when you step out of the plane, you probably didn't sleep, you probably didn't been tired, and you go to a place called primary inspection. Now, on average, a CBP officer has 45 seconds to determine a person's admissibility to the country. Now, think about that. A CBP officer is not going to care about your complicated work schedule or endeavor. They're going to determine whether you either work or establish residence. Those are concepts that are far beyond what we perceived as work or as establishing residence. Okay, their definition is the one that's important because you're asking for admission. If the officer cannot determine your admissibility at primary inspection, they can send you to a secondary inspection. Okay, that's my Mexican clients call it el cuartito, or the little room, where you get questioned, where you're further questioning and about your activities and so forth and so forth. And let's supplement what Maria and Robert said. What is work? The key question that you have to answer, that they answer, is who will ultimately benefit from the activities that you do in the US? Okay? And we can extrapolate a number of scenarios, but who is the ultimate beneficiary? And I'll give you an example. If I go to the US to visit, and I get an Airbnb, and the neighbor wants me to mow their lawn for $20, that is work. Okay. If I'm an installer and I come from a Dutch company that it's installing Dutch material, and the price of my installation fees are included in the price of purchase, by all means, make sure that I bring the contract and to the country and to the entry, but the activities benefit the Dutch company, and that would not be work. All right, let's talk about establishing residence. If I spend 11 months out of the year in the US, even though I work for my UK company remotely, I establish residence. But if I own a vacation home and I only spend 2 weeks in Easter, 2 weeks in the summer, and 2 weeks in Christmas, I'm not going to have an issue. So where your job and your counselor's job is to be where in the spectrum of these activities do you fit? Now, one of the biggest tools that we have is the travel history that CBP has given us in cbp.gov. So the typical timelines, a lot of people say, well, I was detained for 5 hours at the port of entry. True, you were not let go 5 hours, but the resolution of your case may only have been taken 15 minutes. And it's all about the type of airport and the dynamic of the airport that you're applying to. Now let's move to the next slide. Now, are there good or bad airports? That's an excellent question, and I won't give you the details of every airport, but I would say the following: every entry that you make, it's a new application for admission. Okay. The databases don't have any memory, but the time of day that you arrive is very important, because every CBP port operates like every other company. I always advise my clients to arrive on a weekday on business hours. And I don't care where you fly into. You're flying to LA, but you're arriving in Charlotte. I want to know what time you arrive in Charlotte. The reason is the most educated CBP officers, the port director is very likely to be there at Tuesday on 10 a.m. local time than if you arrive on Sunday at 10 p.m. So be aware of what your of your arriving time. And again, it all depends on how difficult or easy to explain your entry is. So if you're coming for a week in Orlando and you have a package, you probably can come in on a Sunday at midnight. But if you're coming on a business trip and you have to explain, and one of the issues that I have with my European clients is that I have to shake them out of the two modes. They're either on work or they're on holiday, and there's a way in between. We have to explain, this is work, and this is a visitor. Now, the benefit, like Robert was saying, of having a pre-clearance airport is that an officer has two options when they determine that someone's inadmissible. They can either let you withdraw your application for admission, or they can do an expedited removal. Now, I'm sure you've heard the news. Things are tougher, and they'll be tougher for the next 3 years and 16 days. But my response is not that the laws have changed, but the referees have become more stricter and they have better tools. And the analogy that I give is just, in football, players could get away more before the VAR was installed. Now that the cameras are there, every kick and every corner gets, every red card gets called and studied and analyzed. That's kind of similar to what we're having. We're living in the world of artificial intelligence, face recognition. We'll talk about your what you should and shouldn't have on your cell phone or mobile. But we have to take consider those considerations. Let's see the other slide. All right. How well or how bad are the CBP officers trained? Let's understand that CBP is primarily a law enforcement agency. As opposed to the Department of State, which is much of a diplomatic, that's where we get our visas, or US EIS, that the last S in their name is service. CBP is first Customs and Border Protection. They are there, and a CBP officer is probably 90% trained on customs violations, and trafficking, all that. I mean, if you sit down with a CBP officer and tell him how was your day, they probably won't tell you, "Well, I refused 10 ESTAs today," and blah blah blah. They will tell you where we got this package that was going, et cetera, et cetera, et cetera. There's even a TV show here in the US about how to catch a smuggler. That's their bread and butter, and they laterally do the immigration evaluations. So your job is to facilitate the communication between you and the port director. There's something called port autonomy that the officers have, that every port has at the direction of every port director. So how they make an interpretation to the national policy is up to the port director. Let's go to the next one because we're going to spend more time there. Okay. Make sure that your conversation, like I tell everyone, let's have these conversations at meetings like this, at our offices, instead of the famous little room at the CBP officer. Having prepared for this is more important than than after the fact. Because once a CBP officer has made a decision, and everybody in this panel will tell you, the fix will probably won't come from CBP. If somebody gets returned, you probably need to go get a visa. You probably need to go get a waiver. And I'll tell you one thing, ever since January of last year, January 2025, I told you that the officer can can let you withdraw your application or can expeditedly remove you. Well, if they expeditedly remove you, you have a bar to entry for 5 years. That you can get a waiver that needs to be recommended by the Department of State, but that waiver takes, give or take, about a year. Unfortunately, here in my practice in San Antonio, Texas, since January of 2025, I have not seen a single instance where an officer let someone withdraw the application. Even for minor infractions, people whose visas were canceled and they didn't know that their visas were canceled are being expeditedly removed, which puts us as attorney into a difficult position of applying for a new visa plus applying to your waiver. So I cannot overemphasize how big preparation is. Now, I usually recommend my clients to have a 2-3 rule. 2-3 words, 2-3 sentences, or 2-3 pages. What does that mean? That means that the purpose of your visit should be communicated to the officer in 2-3 words. If there are follow-up questions, you should have prepared 2-3 sentences. If you get if you get further questioning, you should have 2-3 pages, hopefully prepared by your attorney about the instance, the purpose of your travel, and hopefully that'll explain clearly that your purpose of your travel does not make you inadmissible, that you haven't worked, and that you haven't established residency. One of my favorite types of clients, and they're very legally difficult, are the roaming grandparents. The roaming grandparents, I call them because they have children, they're in their 60s or 70s, they have children in the US and children abroad, and their physical presence is determined by the grandkids' activities or the grandkids' births or what have you. And the one thing that I want you to remember is that the purpose of a tourist and a purpose of a permanent residency are completely incompatible. You cannot behave like a permanent resident in the US as much as you cannot have permanent residency and never touch US oil. So those situations are probably one of the most difficult because I spend a lot of time with them. Well, where do you think you're going to spend more time, et cetera, to define their strategy. Be careful of what you bring to the US as far as your electronic device. Your electronic device is subject to inspection. Now, whether you want to buy a burner phone, we've had issues, but my trick is put that phone on airplane mode and don't turn it on until you pass customs. That way, they can only see what's on the phone and not what you have available online. Let's move to the next slide, please. All right. There's the best strategy that you can do is before you land, go ahead and familiarize yourself with the cbp.gov website. That way you can retrieve your I-94, you can check your entries and exits, and you can have more information about what your activities are. Definitely, if you escalate your activities on ESTA, then you cannot have use of ESTA. One of the things that I do my companies that I recommend to my companies, like if you have a lot of if you're installing that equipment, if you're sending professionals, make sure that you rotate them, that you don't send the same person over and over again, because you're accumulating physical presence, and that will trigger further questioning from the officer. Give you an example. I represent an architectural firm that brings a lot of architects to learn the process and procedures of the U.S. so they can take it back into abroad. Of course, you need what we call the opinion letter outlining, because those opinion letters may not look like much, but when we cite the specific regulation that we want the CBP officer to look at, that may be your saving grace from an expedited removal to an admission. So make sure that you analyze it first. And one of the things, going back to the architectural firm, is that never send the same person twice if they're going to spend 3 to 4 months doing this activity. So, every year they bring 3-4 architects. They spend that 3-4 months, and they go back, and they don't return after at least a year. Sometimes when you have bad history, the best thing to do is spend a considerable amount of time without entering to the U.S. Because we cannot. One of the things that I tell my clients is, we cannot change the facts, but we can dilute them. That means that if I've been lucky enough to spend 11 months out of the year in 2025, my advice to that person is, don't come into the U.S. in 2026. And let's keep monitoring your stay, so you don't trigger the specific questioning that gets you into secondary inspection. Okay, let's move to the next. All right. So what happens when you get detained? When you get to the secondary inspection, you get to the first of all, don't panic. Make sure that you communicate respectfully and clearly to the officer. One of the things that the officers are very good trained to is to lead you into a specific set of facts, so they can write on their Q&A that you're either working or residing in the U.S. So you have to keep calm. You have to be cordial to them. Unfortunately, they have a lot of authority. Unfortunately, you do not have the right of legal representation at a port of entry. Okay? Your constitutional rights do not come to you until you get admitted into the U.S. That's an unfortunate scenario. But because there is no right to legal representation, I see my job to educate my client to the best of my abilities about their rights and obligations before the entry. Now, the trick is, you cannot pick up the phone and call us. Unfortunately, sometimes you can text to us. I'm being detained. Usually more time than enough and it happens more at a land port of entry. I get a call and I said, make sure that did you show them the contract? Did you show them the letter? Did you show them this? Did you show them that? Tell him this, tell him that. one or two keywords can make a difference. Okay, the officer is going to make a determination. If the officer makes a determination, make sure that you get it in writing. You know, everybody in this panel will tell you that it's probably impossible to get the Q&A after the encounter. And that's the legal term that CBP uses, encounter. It's not a detention, it's an encounter. So we can go ahead and develop strategies to remedy it. Okay. Most of the time, the remedy will get, like if you get your ESTA taken away, most of the time it was to get a visa. And then depending on the charges there, it's what type of visa and whether or not you need a waiver for that visa. Okay. Make sure that that the entire record of your conversation is included on the Q&A. Make sure that you review it. You don't have to sign it, but make sure that you that you review it. Now, make sure that you also ask to speak to a supervisor. Okay, every detention, every withdrawal, and every expedited removal has to be signed by at least the officer and the supervisor. If there's a communication gap, you can advocate at the time of detention or at the time of encounter as to the purposes of your visit. That means that if they don't understand that the contract, that there's a contract, et cetera, et cetera. The second reason why I advise you to travel during business days is because let's say that you have a meeting with a US company. The officer can pick up the phone and call the office of that US company to verify what you're doing. Make sure if you're entering at Tuesday at 10 a.m. local time, that's going to be very easy. But if it's Sunday at 10 p.m., nobody's going to answer the phone and the officer's not going to believe you. And you have to this is an exercise of credibility with the officer when you get into these detentions. You have to explain the nature of your activities, and you have to clearly articulate that your company at home, that your company abroad is the one sending you here, that you're going there for the benefit of a foreign company. Okay, and I'll give you an example because we threw this to the officers a lot. We had a lot of conversations with an influencer taking a picture at the Statue of Liberty. Eventually, she's going to get paid, and eventually she's going to get paid, and she's going to get reimbursed by YouTube or Instagram or what have you. But her principal place of business is abroad, and it may come as how incidental it is to come into the United States. And there's a legal precedent about some Canadian food producers that crossed the border and sold their remaining produce to the US only once a year. Okay. That, again, the devil's in the detail, and the totality of circumstances will prevail. Unfortunately, the forum is not the most conducive, to this. But it's your job to facilitate communication, and it all depends on the level of the of your activities and the rapport that you build with the CBP officer. Like if you're very authoritative and you want them to do your will, um, they may take a lot of pleasure in making your life a living hell for the next 2-3 hours and doing your next admission almost next to impossible. So it's to your best advantage to be cordial and try to communicate in a viable and credible way for the CBP officer. Okay, so we have a next slide.
I think what we have here now is I'd love to spend some time. There are a bunch of questions from the audience. So why don't we take some questions here? And for any of the speakers here, thank you so much, Ramon, for all of that great information.
Oh, my pleasure.
Question from the audience was about what could be called laptop travelers, someone traveling for a holiday, for vacation, but working remotely. What comments do we have about folks like that who might be primarily coming for vacation, but they are going to be working too?
Perfect question. The first thing that they're going to ask is the length of the vacation. 6 months is not a vacation.
Yeah.
So if it's 2 weeks, I wouldn't worry about it. If you're going to pick up your laptop and work from Vegas or Orlando, 3 hours a day, that's not a problem. Just make sure that the first words out of your mouth is for the benefit of my UK employer.
Mm-hmm. Mm-hmm. I guess that could become a little bit, again, you talked about the devil is in the detail. If you had a scenario where that company had a US office, but the person was traveling for vacation and wanted to do some work, but didn't actually have a work visa. Maybe there could be some other considerations there.
Right.
It could blur the lines a little bit there.
Yeah, that will require a lot of questioning by an attorney, a lot of preparation, whether ESTA, a B1, or another visa is more adequate for that activity.
Yeah, absolutely. Rob and Maria, do you have any comments about that kind of traveler? Someone coming on vacation but has their laptop. I mean, this is going to be so common now in the age of remote working.
Yeah, I think you're right in that if there is a US office, if their client happens to be in the US and they just work with the client remotely in the UK, for example, um, things can bleed a little bit and it gets a little blurry. I guess really dependent on type of work you're doing, um, what is the company, where are their offices, where is your client, where is the product you're working on being used? If it's being used on for the benefit of a US client as the end client, could be a little bit again, I think Ramon also explained that officers have so much deference at the border and their decision is given so much deference that when it gets a bit blurry, a bit murky like this is when we're in the concern about using pre-clearance ahead of time versus arriving at the border, just because you can sort this all before you get on the plane.
Yeah, great comments. Thanks. There's a bunch of questions coming in, so let me try to get through them. Could we comment on the enhanced social media scrutiny that folks are hearing about? So for those who are traveling under ESTA, there's a lot of talk about, okay, what do they do about their social media profiles, their accounts? Ramon, you commented on phones and what should be done about phones, but maybe you could comment further on that, whether things should be scrubbed. What comments do you have about that?
That's a good question. That's an ongoing conversation with CBP. I mean, liking a post will probably not get you in trouble, But if you're very active on social media and very voicey, that may trigger further questioning. And usually they don't deny you entry because of the post itself. The trick is they that leads into a further investigation, and then they may or may not find something against you to make you inadmissible. That makes any sense.
Mhm, mhm.
That may be the pretext that they'll conduct further inquiry.
Okay. And one other common question is that does it look suspicious if someone sort of completely wipes off their social media profiles off their phone, off their laptop, even if they're just doing it out of an abundance of precaution? Um, is there some
That's
presumption they're hiding something?
right. That's a very good question. Because I remember having a conversation that when, if you're an 18-year-old and you don't have Instagram, it may look suspicious in and of itself that you don't have any social media presence. But I would caution everyone to take a second look. It might not be a bad idea to go to a consultation with an attorney and say, this is what I do. I mean, if it's very active, if you think that you have an issue, by all means say, well, this is my concern.
Yeah.
Because one of the things that, the best tools, like I said, is writing those opinion letters.
Yeah.
And those opinion letters, I usually address them to the client themselves, but is for the officer's review. And the reason why I address them to the client is that the officer doesn't care what I have to say. I
Right.
just want to educate my clients. Well, this is risky, but you did, whatever the narrative is,
Yeah.
you can look at it and probably pre-solve it. It's like getting a vaccine. Is it a guarantee that you're not going to get COVID? Probably not, but it's the best line of defense that we get.
Yeah, yeah. Okay, great. Let me just breeze through as many further questions as I can here. Thanks. So do officers have any knowledge in advance of who's traveling into the US? In other words, is there a passenger list that they receive? And so do they kind of have an idea in advance of who they might target, for example,
Yeah.
for further questioning?
Yes, every plane receives a pre-flight list, and if somebody triggers the databases, yes.
Okay. So even if they can board the plane, even if they've cleared ESTA or what
Right.
have you, they could again still land at LAX or JFK
Right.
and already be singled out as someone who might need to go through further questioning.
That is correct. Mhm.
Okay. Another one is can if one goes through secondary inspection, can can that interview or questioning be recorded on one's phone, or does one's phone have to be turned off?
I don't think that an officer, it's up to the officer, but I don't think an officer will allow you to record for you to record the interview
Yeah.
or the. Mhm.
Okay. Another question, I don't know if we can get through all of them, but let's try, is this is an interesting one. Can CBP see travel history of internal flights around the US or just entry and exit in and out of the US?
Just assume that they can see everything.
Yeah.
I mean, they were told that the new technology is facial recognition, and I think they tried it in a couple of land posts, and they find like 80% more encounters than they would without facial recognition. So
Mm-hmm.
they're constantly upgrading their database. I wouldn't
Right. Quite.
doubt.
Yeah, that's a quite important comment there. And presumably, did you comment on AI? I mean, they're embedding AI, right, into
Right.
all of their inspections now. Yeah, okay. Few other quick ones is okay, this is a difficult one to answer. There's not really a clear black or white answer here. Someone asked what would be considered a long business trip. Would 10 days visiting multiple clients and multiple considers be considered a long trip? That's
No,
purely no, not necessarily no. In my view, I probably all of us would say 10 days would be seen as a relatively routine business
right.
visit. Yeah. And then there's a question about construction project managers on behalf of a UK business going out to the US if overseeing on a site for a couple of weeks. The benefit would be to the UK business, subcontractors would be US. My view is that they're overseeing a project that is
Right.
a danger zone.
The word construction scares me because it's in the regulations, like that construction work is extremely prohibited from so I would spend a few hours with that construction company to delineate and make sure that there's a contract in there where you limited the scope of supervision.
Yeah. Very useful. And final comment is about whether family members, teenage children, are they scrutinized as heavily with respect to social media? I would assume yes, everyone is being scrutinized.
Especially students. If you come with an F1 student, you have to disclose. And that's where the comment came in. If you're a 18, 20-year-old and you don't have social media presence, we're going to look further into you.
Yeah. That's really all we have time for. I wanted to have a few minutes of kind of little takeaways, but we're out of time. So I hope that the audience found this useful. Here are our contact details if you'd like to reach out to any one of us. Thank you very much, speakers, for being with us today and for sharing your insight and your expertise on this very important topic. And thank you to the audience for participating in the webinar today. Have a wonderful day. Thank you.